The House Administration Committee held a hearing to examine Congress's internal sexual harassment policies. Committee member Jackie Speier, a sexual assault survivor, spoke as a witness in this hearing. We'll also hear testimony from legislative branch staff about how sexual harassment allegations are investigated. This is an hour and 40 minutes.
I now call to order the Committee on House Administration for purposes of today's hearing titled Preventing Sexual Harassment in the Workplace. The hearing record will remain open for 5 legislative days so members may submit any materials they wish to be included. A quorum is present, so we may proceed. At the outset, I ask for unanimous consent that Committee on Ethics Chairwoman Susan Brooks and Ranking Member Ted Deutsch be afforded the opportunity to sit on the dais and question all of our witnesses today. Without objection, that's approved. I also ask for unanimous consent that Representative Speier be afforded the opportunity to sit on the dais and question our second panel of witnesses. Without objection, so ordered. I'd like to thank all of our witnesses for taking time out of their busy schedule to be with us today on this very serious issue. And I commend Speaker Ryan for bringing this important issue to the forefront and for tasking this committee to undertake a comprehensive review. Today's hearing is a critical part of that review process. First and foremost, let me say that there is no place for sexual harassment in our society, period, and especially in Congress. This is an extremely important topic, and it will take all of us working together to effectively address this issue. I believe as members of Congress, we must hold ourselves to an even higher standard, a standard that demonstrates that we are worthy of the trust placed in us by our constituents and the American people. The disturbing accounts of sexual harassment experienced by current and former members, including one of our witnesses today, revealed that sexual harassment is a serious problem in our society, and Congress is not immune from this issue. It's no secret the culture on Capitol Hill is unique. While there are 441 employing offices in the House among members and representatives, we should all share the common goal of creating safe and effective work environments that are productive, collegial, and responsive to the needs of our staff, constituents, and the public. The personal accounts described by our current and former colleagues and staff suggest that not every office is achieving this goal. These accounts dictate the need for a comprehensive review of the House's policies and procedures, as well as the resources available as it relates to sexual harassment in the workplace. Currently, sexual harassment awareness training is not mandatory for members and staff. There is also concern that victims of sexual harassment are not aware of the resources available to them. Some have criticized the process that currently exists to adjudicate claims of sexual harassment. Today we'll hear from 2 members, one of whom was a victim of sexual harassment while a congressional staffer, and the other who specialized in employment discrimination litigation, including sexual harassment cases, before his election to Congress. In addition, we'll hear from representatives of the Office of Compliance and the Office of House Employment Counsel, 2 entities that are responsible for providing training and resources to members and staff, among other services. The Office of Compliance is an independent agency established by the Congressional Accountability Act to administer and enforce the provisions of the Act. While the Office of Compliance is responsible for educating and training members, staff, and the public on workplace issues, there are individuals like Representative Speier and Holmes Norton who have spoken publicly about the need for the Office of Compliance to do more. The Office of House Employment Counsel, located within the Office of the Clerk, provides training and resources for members and chiefs of staff, as well as training for the entire office. In addition, the Office of House Employment Counsel represents employers in the Office of Compliance proceedings. Several bills and resolutions have been introduced in the House seeking changes to the process, many of which involve making training mandatory for all members and staff. According to the Office of Compliance, and I quote, "It is widely acknowledged that anti-discrimination and anti-retaliation training for employees provides many benefits to the workplace. Education directly impacts employee behavior. A comprehensive training program continues to be the most effective investment an organization can make in reducing complaints and creating a more productive workforce." Now, I believe we need mandatory training. I think probably everyone here will agree, as well as a more organized and comprehensive approach to address sexual harassment in the congressional workplace. As I said at the beginning of my remarks, the hearing is just the first step in our review. I look forward to hearing from each of our witnesses today on both panels. Mr. Brady, I'll now recognize for the purposes of an opening statement.
Thank you, Mr. Chairman. And Mr. Chairman, thank you for calling this hearing today. The congressional workplace should have zero tolerance for sexual harassment and any kind of discrimination. That's why I was pleased to be one of the first sponsors of the Congresswoman from California's resolution. Congresswoman Speier's courage and her determination deserve the respect and attention of members of Congress, and her plan deserves action. I thank her very much for being here today. The Congresswoman's proposal will require mandatory training for members and staff. It will also require the Office of Compliance to get back to us very quickly on additional improvements to their program. This bipartisan legislation is a first step, and the House should pass it immediately. I want to emphasize that this should be just a first step. I hope we can also look at ways to strengthen and clarify our dispute resolution process and other ways to support the Office of Compliance, including with additional money. I have supported additional appropriations for the Office of Compliance every day I have asked, and it's an important agency worthy of our support. I thank our witnesses for being here today, and I am glad that Mrs. Speier will be joining us on the dais after her panel discussion. I'm also pleased the ranking member of the Ethics Committee, Mr. Deutsch, will try to join us, since the Ethics Committee will have a role to play in holding all of us to the highest conduct. Again, thank you, Mr. Chairman, and I yield back the balance of my time and look forward to our witnesses' testimony.
Thank you, Mr. Brady. I'll now recognize Barbara Comstock for the purposes of an opening statement.
Thank you, Mr. Chairman. In recent weeks, sexual harassment and sexual violence by powerful men has come to light as never before. People have named names, and there is a renewed recognition, rightfully, of this problem and the need for a change of culture that looks the other way because of who the offenders are. Whether it's Bill Cosby, Harvey Weinstein, Bill O'Reilly, Mark Halperin, Roger Ailes, Kevin Spacey, or one of our own, it's time to say no more. I've been an intern in this body. I've been a staffer, like our witnesses here today. I've been a counsel on committee, and now as a member. So I particularly appreciate the opportunity for this hearing today. And I appreciate that we have already committed to mandatory sexual harassment training for all of the members, I emphasize members, and staff. And I think we do have a consensus of need to have improved training materials and practices, making sure we are getting better reporting, a better response, feedback loop, really knowing what's going on with surveys or other type of things, but most importantly, to protect the victims. And I know we'll be exploring that in weeks to come. We need to know more of examples of what is actually happening and making it easier for the victims to come forward. We know there are still many who are in the shadows or forgotten because their situations may have happened at a time where less attention was paid. Last night I had the opportunity to talk to Dorina Bertucci, who in 1988 filed the Hill's first successful harassment complaint 30 years ago against Representative Jim Bates of California. In a recent interview and roll call, and I hope you've seen that if you haven't read it, she noted how she had many women in her office who had the same experience, but only she and one other came forward. But she felt it was so important. In speaking with her and seeing how brave she had been, because this was 30 years ago, you could hear the pain still in her voice in telling that story, but you could also hear the strength and the resolve. And women need to hear that and know that we'll be there to back them up. And we know, and I think it's important we name names. I mean, the Hollywood rumors, all these things, people had heard these rumors for years. One of Roger Ailes' victims was a friend of mine. I never knew this had been something that had happened to her until I read her story in the New York Times. And I knew it was true because I knew her, talked to her about it after. But I was here in the time of Bob Packwood, Charlie Wilson. I think of some of the things, Charlie Wilson said, you could teach him to type, but you can't teach him to grow, I was like, breasts. He used a more vulgar term. And I wanted to close with something that I just had somebody tell me recently. This is about a member who is here now. I don't know who it is, but somebody who I trust told me this situation. This member asked a staffer to bring them over some materials to their residence. And the young staffer, as a young woman, went there and was greeted with a member in a towel. It was a male, who then invited her in. At that point, he decided to expose himself. She left, and then she quit her job. She left, she found another job. But that kind of situation, what are we doing here for women right now who are dealing with somebody like that? So this is really a much more complex situation than I think we need to have more training, know about the violence that we're seeing in some of these that are criminal. Like we get people into the criminal system when you have a crime. I would argue that probably is a crime in that situation. And have people know that. And then that we have a much better process so that that person doesn't have to give up her career. I was listening to one of the victims of Mark Halperin, and she was talking about how she was very strong, left, didn't do anything. But there were other women who left their desired profession altogether because of what had happened, and we can't have that happen. So, Mr. Chairman, I really appreciate your giving us this opportunity, and I know we're going to have more hearings. I think it's important that we do that and that we hear more from the people who have been out in the shadows. Thank you.
The gentlelady yields back. The chair will now recognize Congresswoman Zoe Lofgren for purposes of an opening statement.
Thank you, Mr. Chairman. There's no question that sexual harassment in the workplace, including Congress, must be addressed. And I want to thank Chairman Harper and Ranking Member Brady for today's hearing on this important subject. And I want to thank the witnesses, Congressman Bradley Byrne and Representative Jackie Speier, for coming before us today to help us examine how we can make improvements to our policies and procedures for preventing sexual harassment, as well as for handling complaints once they're filed. Now, Representative Speier's resolution, the CEASE Act, calling for mandatory sexual harassment training is a step in the right direction, but as she and I have discussed, it's not the end. We need to examine dispute processes at the Office of Compliance to make sure victims can expeditiously have their grievances heard. And I think this is especially important because sexual harassment is often about power. It's not just about sex, it's about abuse of power. And our hardworking staffs and others need to have an advocate just as powerful on their behalf. Mandatory training is long overdue. The Office of Compliance has been recommending it for 20 years, and the Senate just unanimously passed a resolution mandating it last week. Seems to me if Senator Ted Cruz and Elizabeth Warren can agree, we should also be able to agree on our side of the building. The online training is just a small start, but study after study shows that in-person training is where you have the most progress in changing workforce behavior. We need to do a better job of advertising the resources that are available, but we also need improvements in the process once people do make a complaint. I just want to make a special word about Congresswoman Jackie Speier. Years ago, she and I were staff compatriots. We worked on the Hill at the same time. She worked for Congressman Leo Ryan from the Mid-Peninsula, and I worked for Congressman Don Edwards, just south of that district. It was a wild and crazy time in many ways in our history. We had the impeachment of Richard Nixon, the war and the disruption and the like. But one of the things that Jackie has talked about now, and I give her so much credit, is the assault that she suffered. I think it is so important that she had the courage and the grace and dignity and grit to speak up about what happened to her. And I know that that has encouraged other people to step forward and take art and know that they can speak up too. So I just want to thank Jackie for being here today, for the lead that she has taken on this issue and so many others. She's a great lawyer, a terrific leader, and not afraid of a darn thing. So thank you, Jackie, Congressman Byrne, and I yield back the balance of my time.
Gentlelady yields back. Anyone else on Republican side wishing to be recognized for an opening statement will recognize Ms. Brooks for 5 minutes for an opening.
Thank you, Chairman Harper and Ranking Member Brady. As chairwoman of the House Ethics Committee, I'm really very pleased to be a part of this hearing today. We know in the House Ethics Committee that the House does have problems with addressing both reported and unreported sexual harassment, as just described by Representative Comstock. And the House Ethics Committee is committed to working with your committee to eliminate harassment that occurs through ensuring that our members and staff are trained and have better training. And we need to ensure that we are protecting the victims of harassment when it does occur. Sexual harassment is strictly prohibited by our Code of Official Conduct. Let me repeat that. Sexual harassment is strictly prohibited by the House's Code of Official Conduct, and something that the House Ethics Committee takes very seriously. For background, at the House Ethics Committee, we have two separate functions as they relate to sexual harassment. First, we have an Advice and Education Division. The attorneys in Advice and Education are trained when approached with a harassment issue to advise the person seeking advice to contact Office of Compliance. These discussions with our attorneys on our committee are strictly confidential, so I cannot report on the number of harassment instances raised with the committee. But I can report that the advice given is to educate the advice seeker on their options. The second function of our committee is to conduct investigations when allegations are made. And should someone be interested in initiating an investigation, they can contact the House Ethics Committee Investigation Division. The committee and I personally share this committee's goal of protecting victims of harassment. I look forward to learning from this hearing ways we can improve the House generally and how we can ensure that we take the lessons learned from today's hearing and improve the House Ethics Committee processes as well. And in closing, I would like to just commend the three female members here who've just shared, and as we've learned, all started as staffers. And it's very important, and I'm just pleased to be a part of this today. I was not a staffer here on the Hill, had never worked on the Hill prior to coming to Congress, but I think it's very powerful that the three of you who are here in many ways representing House staff and now as strong voices on behalf of not only your districts, but on behalf of the country as members. So thank you, and I yield back.
Congresswoman Brooks yields back. The chair will now recognize the gentleman from Maryland, Mr. Raskin, for the purposes of an opening statement.
Mr. Chairman and Ranking Member Brady, thank you very much for calling this hearing, and I also want to thank our distinguished witnesses for their leadership and their perseverance in dealing with this issue. The nation is in an uproar today over sexual assault and sexual harassment. From the studios of liberal Hollywood to the studios of Fox News, from Wall Street to Alabama, there is a tectonic shift taking place in women's unwillingness to put up with what prior generations of women were often forced to accept as business as usual. And I believe the public generally has seen enough too and wants action. In Congress, we must be leaders in changing a culture of sexual harassment and assault, not just by what we say in our legislation, but by what we do in our own workplace. Justice Brandeis once said, "Our government is the potent, the omnipresent teacher. For good or for ill, it teaches the whole people by its example." Mr. Chairman, sexual harassment at work is a pervasive problem that's been documented. The EEOC estimated that anywhere from 25% to 85% of women have experienced sexual harassment in the workplace. And let's be clear that it is illegal, whether it takes the form of quid pro quo, sexual harassment, or hostile workplace environment. harassment. It constitutes sex discrimination, and it degrades the professional status and social position of women. To think that this body is somehow immune from sexual harassment and abuse of women would be naive at best. At last count, more than 1,500 former staffers signed a petition directly calling on us to reform policies aimed at preventing sexual harassment and adjudicating complaints. My chief of staff, Julie Tagan, who has spent most of her career on Capitol Hill, says she does not know a single woman in her age group who has not experienced inappropriate conduct in the workplace. As businesses across the country face their responsibilities for creating harassment-free workplaces, we must do our own part and lead by example in the public sector. A critical first step is requiring annual mandatory sexual harassment prevention and response training for members of Congress and staffers alike, just as we require ethics and cybersecurity training. I am a proud co-sponsor of Representative Speier's CEASE resolution, House Resolution 604, the Congressional Education About Sexual Harassment Eradication Resolution. And I would urge the House to quickly move to adopt this measure as the Senate did last week. Although this is an important place to start, mandating annual sexual harassment training is not sufficient. We must examine existing dispute resolution processes, which recent incidents suggest may be acting still as a deterrent to reporting and resolving problems. I'm eager to hear from our witnesses today on what more can be done, and I understand that there are multiple proposals that have been put on the table aimed at encouraging reporting, soliciting feedback, promoting a healthy workplace environment, and protecting staffers against retaliation. I'm eager to learn how we can work together in a completely bipartisan way, Mr. Chairman, to create a workplace safe for all of our employees and that all Americans can be proud of. Thank you, and I look forward to the testimony today.
Gentleman from Maryland yields back. I'd now like to introduce our witnesses on our first panel. Representative Jackie Speier represents California's 14th Congressional District. She serves on the House Committee on Armed Services as the ranking member of the Subcommittee on Military Personnel and on the House Permanent Select Committee on Intelligence. She received her BA in Political Science from the University of California, Davis, and a JD from UC Hastings College of the Law. Representative Speier has been and continues to be a tireless advocate for women's rights. We appreciate her efforts in raising awareness of sexual harassment and being with us today. Representative Bradley Byrne represents Alabama's 1st Congressional District. In Congress, Representative Byrne serves on the House Committee on Armed Services as well as the Education and Workforce Committee. After completing his undergraduate studies at Duke University, Representative Byrne received his law degree from the University of Alabama School of Law. He practiced labor and employment law in Alabama for over 30 years. During Representative Byrne's practice, he advised multiple businesses on harassment policies, protocol, and procedures, and litigated numerous employment cases. He also has overseen multiple sexual harassment investigations over his many years of practice. So Representatives Speier and Byrne, the committee has received your written testimony. You'll now each be given 5 minutes to present a summary of that submission. And to help you keep time, as you've done on the other end, you know how it works. 5 minutes, with 1 minute to go, it'll go yellow. With time up, it'll go red. And we certainly want to thank both of you for this time. So the chair will now recognize Representative Speier for 5 minutes for her summary.
Chairman Harper, Ranking Member Brady, members of the committee, thank you so much for the opportunity to speak to you. And let me begin by saying how impressed I am with the seriousness with which you are undertaking this issue. It is complex, and it will be at times uncomfortable to deal with it. It's important to note that 2 out of 3 sexual assaults go unreported in this country, and oftentimes sexual harassment leads to sexual assault. Since I shared my own story on /MeToo Congress, I have had numerous meetings and phone calls with staff members, both present and former, women and men who have been subjected to this inexcusable and oftentimes illegal behavior. In fact, there are 2 members of Congress, Republican and Democrat, right now, who have been subject to review, or not have been subject to review, but have engaged in sexual harassment. These harasser propositions, such as, are you going to be a good girl, to perpetrators exposing their genitals, to victims having their private parts grabbed on the House floor. All they ask in return as staff members is to be able to work in a hostile-free work environment. They want the system fixed and the perpetrators held accountable. I've been working on this issue since 2014 and believe there are 3 steps Congress needs to take to fix the egregious and sometimes illegal behavior. The first step is to require sexual harassment prevention and response training every year for both members and staff, just like ethics and cybersecurity training. The existing Office of Compliance online training model is a start, as some of you have pointed out, but it is not adequate. Research has found that effective training requires in-person, interactive instruction and dialogue. A simple change to the House rules will achieve this result, and there's already legislation co-authored by many of you, H.R. 604. And I want to give a special thanks to Ranking Member Brady, Representatives Costello, Palinquin, Lofgren, and Raskin for their co-leadership on this issue. Second, we can fix what we don't know. In my experience working on sexual harassment and sexual violence on college campuses, in academia, and in our military, climate surveys are conducted regularly and are key to recognizing the scope of the problem and to evaluating the effectiveness of reforms. That's why Congress should institute a congressional climate survey every 2 years. Third, we must reform the broken dispute resolution system. The present system may have been okay in the dark ages. It is not appropriate for the 21st century. Under the current process, as you see on the monitor, congressional employees are at best unaware or confused, and at worst are utterly betrayed. This flow chart shows the current process. First, you report the incident to the OC. You then have mandatory counseling for 30 days. After that, you are required, and I underscore required, to sign a non-disclosure agreement before you even begin mediation. You then have mandatory mediation for 30 days. Additionally, the harasser and the member's office are represented by House of Representatives Counsel. Now listen, how does that compute? They are provided free legal counsel. The victim is not. I've also heard from mediators who say congressional process is atypical in that survivors don't have the option to be in separate rooms as the defendant's counsel, and that survivors are often addressed in an aggressive manner. Additionally, the fact that House counsel works on behalf of the alleged harasser during mediation and then is charged with advocating to this committee for the settlement agreement on behalf of the survivor seems to be a conflict of interest. If the employee makes it this far, they then have to go through another 30 days of what they call a cooling off period. So now 90 days have elapsed, and that employee is still required to work in that legislative office, or else they're not eligible for services through the OOC. Now, I might also point out at this junction that interns and fellows don't even have this process to access. So they have nowhere to go. After the 30 days cooling off period, then you can either file a formal complaint in a federal district court, or you can have an administrative hearing where there's negotiations, the settlement is approved, and then we move forward. So, for the few survivors who secure a settlement, there is no disclosure of the office involved or the amount of funds. Taxpayers foot the bill, and the harasser goes on with his or her life. There is zero accountability and zero transparency. I might also add that during that process, the victim can't even communicate that they are going through an OOC process to their family, to their friends, or to anyone in their religious community. So it's really no wonder that staffers do not seek this process at all. And finally, as one of them said to me, who I met with last week, I'm a single mother. I can't afford to lose my job. The thought of being blackballed in this institution, the thought of being somehow subject to reprisals, all of that has an effect. So I really feel that it's important for us to move forward, not just with training, but to move forward with a comprehensive reform of the Office of Compliance. Mr. Chairman, I would like to ask unanimous consent to submit the letter for the record of some 1,500 former members of staff in Congress, and I think I've made copies available to all of you. If you flip through those pages, you will see that they range back into the 70s all the way to the current time. So,
Without objection.
With that, I yield back.
Thank you, Congresswoman Speier, for that very powerful and insightful testimony that you've given us today. The chair will now recognize Representative Bradley Byrne for the purposes of an opening statement. We look forward to hearing from you, Congressman Byrne, on your experience to let us know what's happening in the private sector and your time that you spent working on those cases. So the chair now recognizes you for 5 minutes.
Thank you, Chairman Harper, and Ranking Member Brady, members of the committee. I appreciate the opportunity to testify before the chair on this important topic. Title VII of the Civil Rights Act of 1964 prohibits discrimination on the basis of race, color, religion, sex, or national origin. In 1986, sexual harassment was recognized by the Supreme Court as a violation of Title VII. In 1995, Congress passed the Congressional Accountability Act, or CAA, subjecting us to Title VII. Based on my prior experience and recent research into the current policies regarding harassment here in Congress, I want to make a few observations and offer some of my own suggestions. First, we need to mandate harassment training. I strongly believe the House should require mandatory sexual harassment training for all members and employees. Recent events have demonstrated that training, while available to members of Congress and employees, is underutilized. I will also note that mandatory training in the House is not unprecedented and is already required for ethics and computer security. There are also multiple harassment trainings currently provided by different congressional support offices. It's my opinion that this committee should settle on one high-quality training product to make sure that all House employees are trained in the same manner. Number two, we should consider a universal harassment policy for all House employees. Although not required by law, creating and enforcing anti-harassment policies is now a near universal norm in the private sector. As you are aware, each individual congressional office is an independent hiring authority, and each office has its own policies. Given the unique nature of House employment, it is my opinion that a uniform, universal anti-harassment policy based upon the CAA and applicable to all House members and employees would be much more effective in curbing unwanted sexual harassment than the current patchwork of different harassment policies that we have today throughout offices on Capitol Hill. With a universal policy, the training of House employees would be simplified and made consistent across the House. Number three, we should examine the Congressional Accountability Act and consider improvements to the complaint and enforcement process. It's been over 20 years since Congress enacted the Congressional Accountability Act. I believe this is an opportune time to revisit and consider revisions to this important statute. The statutory provisions governing harassment claims in the legislative branch are different than those that govern private sector employment and other public employees. In the private sector, the EEOC administers and enforces laws against workforce discrimination. The EEOC investigates discrimination complaints based upon a protected class. The process begins by an aggrieved party filing a charge with the EEOC. The EEOC then has the option to request the parties engage in mediation. However, mediation is not required for either party. If mediation is not requested or it's unsuccessful, the EEOC has investigatory power, including subpoena power. After the investigatory process is complete, the EEOC has the right to bring a case upon an aggrieved individual's behalf or to issue the individual a right to sue letter, allowing the aggrieved party to bring litigation. In contrast, the Office of Compliance has no investigative authority and cannot prosecute harassment claims. And the CAA requires mandatory counseling, as Ms. Speier pointed out, for those making claims. We should work to bring the OOC process and authority in line with that of the Equal Employment Opportunity Commission. Other suggestions for revisions to the Act, in my opinion, would include subjecting our unpaid workforce, such as interns, pages, and fellows, to the Act's anti-discrimination provisions. Certainly, these changes will increase the workload of the OOC, and we need to be prepared to provide them the necessary appropriations. Fourth, we need to increase member accountability. Given the constitutional nature of our offices, member-on-member sexual harassment is not something where harassment law and the employment structure can easily be applied. In this matter, it is my opinion that we must exercise our constitutional duty to discipline our own membership. I believe we should adopt a specific policy for this kind of behavior in our Code of Official Conduct, more expressly than one we presently have, that would send a signal that member-on-member sexual harassment will not be tolerated, and that members of this body support those being harassed and reporting these incidents to the Ethics Committee. Moreover, while an employee may be able to obtain monetary relief under the CAA, a settlement or judgment is paid by the taxpayers. Personally, I find this unacceptable. If a member of Congress settles a claim as the harasser, or is found liable as the harasser, it is my belief that the member should be personally liable or required to repay the Treasury for such damages. Furthermore, any payment out of the Treasury in response to a claim of discrimination or harassment by House office should be made in a manner that is fully transparent. Finally, it is my opinion that given the inherent power differential between a member and their staff that they supervise, we should include a strict prohibition on members engaging in a sexual relationship with staff under their direct supervision. In closing, I appreciate the opportunity to share my observations and would be happy to provide more information to the committee as necessary.
I want to thank you, Congressman Byrne, for your testimony and with your experience that you bring. And Congresswoman Speier, we want to thank you as well. I know that this is such an important issue. And you've given us much to think about as we go through this review process. So with that, we'll excuse you, and I believe Congresswoman Speier will move up to the dais.
Mr. Chairman.
We'll now take just a moment to get our second panel in place.
Mr. Chairman, the Judiciary Committee has the Attorney General as a witness in oversight right now, so I'm going to excuse myself.
I want to thank our witnesses on the second panel for being here and taking the time to come educate us as we discuss this very serious issue of how we're going to prevent sexual harassment in Congress as we go forward. I'd now like to take a moment to introduce each of you. Mrs. Barbara Childs Wallace currently serves as the chair of the Board of Directors of the Office of Compliance. She received her undergraduate degree from Purdue University in 1973 her JD from Loyola University of Chicago in 1977, and an LLM in labor law with highest honors from the National Law Center of George Washington University in 1979. Ms. Childs-Wallace has worked at Carter, Child, and Caraway since 1983 in the field of labor law, giving her 37 years of experience in this area. She also served as chairman of the Labor and Employment section of the Mississippi Bar Association. We welcome you, Ms. Childs-Wallace. Ms. Gloria Lett currently serves as counsel to the Office of House Employment Counsel. She received her undergraduate degree from State University of New York and her JD at George Washington University. Prior to serving as counsel, Ms. Lett was a corporate attorney handling employment law issues and litigation for a large telecommunications company. She also served as an assistant corporation counsel representing the District of Columbia in civil litigation, as a special assistant United States attorney for the District of Columbia handling criminal prosecutions, and as an attorney for the Equal Employment Opportunity Commission. We welcome you, Ms. Lett. The committee has received each of your written testimonies. Each witness will have 5 minutes to present a summary of that submission. As you know, to help you keep the time, when I recognize you, the light will be green for 4 minutes. It'll turn yellow for the last minute and red when the time is up. So at this time, the chair now recognizes, for the purposes of an opening statement, Mrs. Barbara Childs-Wallace.
Good morning, Chairman Harper, Ranking Member Brady, distinguished members of the Committee of House Administration, Congresswoman Speier, and Congressman Byrne. It's an honor to be here today representing not only the Office of Compliance, but its Board of Directors, which I chair. The other members of the board are Susan Robfogel from New York, Roberta Holtzworth from Illinois, Barbara Kamens from the District of Columbia, and Alan Friedman from California. And we were appointed to these part-time positions on the board by the majority and the minority leadership of both houses of Congress. We're required by the Congressional Accountability Act, or commonly known as the CAA, to each have professional expertise in the application of the workplace laws that apply to the legislature by the CAA. In fact, all 5 of us who are in private practice have decades of experience within the private sector, and a few of us also within the federal government in both labor and employment and discrimination issues. The CAA also requires that we are to be appointed without regard to political affiliation. Our board has been serving since 1999, and we've worked diligently and in a nonpartisan manner during this time to try and ensure the rights of all individuals working on the Hill, that they are protected. I also want to thank the members of our staff, many of whom are here with me today. The OOC has a huge mandate from the statute, which we accomplish with approximately 20 full-time employees. They're very skilled and equally committed to the tasks laid out for us by the CAA. Finally, I want to especially thank Chairman Harper, who just happens to be my congressman from Mississippi. I'm originally from the Chicago area, but for the past 34 years, I've practiced employment law in Jackson, Mississippi. It's nice to see a neighbor holding the gavel, and we appreciate the fact so much that you have called for this important hearing to take place. As you know, Congress, and has been testified to already, Congress created our office in 1995 under the CAA, which has incorporated 13 federal workplace laws that are applicable in the private sector and the executive branch to the legislative community. This act designates 3 primary responsibilities for our office, although there are many other statutory functions that are performed in addition. First, we inspect the Capitol grounds and the legislative branch facilities to ensure that our community is free from occupational safety and health hazards and is accessible to persons with qualified disabilities. Second, and especially pertinent to the subject of this hearing, we provide an alternative dispute resolution program to covered employees who seek to assert their rights under the CAA. And third, also pertinent to this hearing, our office maintains a robust and comprehensive outreach and education program to this community about their rights, responsibilities, and protections under the Act. In addition, the CAA mandates that our board report to Congress every 2 years on our recommendations for changes to the CAA based on the labor and employment laws in the private sector and in the executive branch. Mr. Chairman, since 2010, our board has zealously advocated in these biennial reports, also known as our 102B reports, for mandatory training on how to prevent and remedy harassment, discrimination, and retaliation of all sorts in the entire legislative community, the sort of training that is regularly performed in the private sector and in the legislative branch, in the executive branch. It is with great satisfaction that we see that this committee and the many lawmakers on Capitol Hill are responding to this recommendation. Before harassment can be corrected, everyone in the legislative community must understand the meaning of harassment, how to respond to it, and more importantly, how to avoid it. Consistent with our statutory mandate to inform and to educate individuals within the legislative branch, our board believes that mandatory training on harassment, discrimination, and retaliatory behavior will provide the best avenue to not only avoid the conduct in the future, but to help transform the legislative branch into a model work environment whereby the lawmakers can and do lead by example. This concludes my remarks, and I ask that my extended statement that has been submitted to the committee be included in the record of this hearing. I now look forward to any questions that you might have, and thank you again.
Thank you so much for your testimony. Chair will now recognize Ms. Gloria Lett for 5 minutes for the purposes of an opening statement.
Good morning. My name is Gloria Lett, as you know, and I'm one of the attorneys with the Office of House Employment Counsel, also known as OHEC. OHEC is basically an in-house law firm available to members of Congress, each of which is a separate employment office, committees, House officers, to provide advice and counsel on the various issues that arise under the Congressional Accountability Act, and specifically, for purposes of this hearing, the question of sexual harassment. We are there as a partner with employment offices to help them understand the issue of sexual harassment and to help them prevent and address the issue of sexual harassment when it does occur in the workplace. I'm very grateful to be here to have this opportunity to talk about my office and the resources that we do provide to House employment offices. OHEC basically has 3 core functions. Those are to provide counseling, to provide training, and to provide representation and litigation when employees raise claims of sexual harassment in their workplaces. The way that manifests itself, and I think it's important to keep in mind that our office is a nonpartisan office. All contacts with our office are confidential, protected by the attorney-client privilege. And so when we are called by employment offices to talk about these issues, I think it's a good model in that they can speak frankly to us, we can ask difficult questions, we can learn the good and the bad and the really bad, and give them advice and counsel on how to address those issues. We talk about the legal issues, but more importantly, we talk about how the office can address issues and take appropriate corrective action to make sure that the behavior stops. That corrective action can range from counseling, sending an employee to training, or discipline up to and including termination. And there is accountability in congressional offices and House offices for individuals who engage in harassment. Sometimes they are indeed fired. The other part of our role is to provide training. We provide training on a request basis. We provide training on a regular basis. The House officers and the IG, for example, schedule mandatory training for all new employees and all new managers. And they schedule that directly with our office, and we conduct that training. We also do training after there has been an issue of sexual harassment. So we go to district offices as a follow-up to make sure that the behavior doesn't happen again. And we do it on a request basis for those offices that are proactive on these issues. We do 3 types of training, actually. One is anti-harassment training that is specifically for employees. Again, that's on a request basis by an office, and we educate employees about what sexual harassment is. That's in-person training. We have vignettes and video where we stop the training at each section and we explain the behavior and we have a conversation so that employees understand what they've seen and how it can be unlawful and how they can report that behavior to their management so that it can be addressed. We also do something called sensitivity training. The sensitivity training is broader because, as you know, sexual harassment is unlawful under Title VII of the Civil Rights Act, but so is racial harassment, and so is harassment based on an individual's religion. So we discuss those broader issues, but we also discuss sexual harassment in the context of that training. And lastly, we do training for managers. And that training, in my view, is vitally important to be in-person training because managers have to navigate around a lot of issues in order to properly handle the issue of sexual harassment. Not only do they face claims by employees who allege harassment, but they could also face claims by an employee who has been accused of harassment if the office doesn't properly investigate the issue and conduct it in a fair manner. So if someone is accused of harassment and they feel that it was unfair or discriminatory, the result, they can also sue the office. And so we help offices manage that. And lastly, we do represent employing offices in litigation when an employee goes to the Office of Compliance. Sometimes we know that those cases are going to happen because we've advised the office and they've done everything in their power to correct the issue, and sometimes we don't know about it. And so we do represent them and do corrective action in that context as well. Thank you.
I want to thank both of you for taking the time to be here and to educate us as we go through this critical review process and come up with a plan to make sure that we do prevent future cases of sexual harassment and hopefully decrease your workload in the process. So at this time, the members will have an opportunity to ask questions, and I'll now begin by recognizing myself for 5 minutes for questions. And I'll start with you, if I may, Ms. Childs-Wallace. And I want to thank you for that insight you've given us to highlight what the Office of Compliance's adjudication process is. So I've got a couple of questions just to make sure we understand that fully. I want you to describe the importance of each step in the process, and, for example, how important is the counseling intake step that you have, and why is confidentiality important during this phase?
The counseling process, I think, is somewhat of a misnomer. It is more like an intake process. It's not therapy to the person who comes in seeking or initiating the counseling step. People who come to us often, well, most likely are not lawyers. They don't know the statutes necessarily, and they need assistance to see whether or not their claims fit within the context of the 13 laws that are applicable under the CAA. To give you a very basic example, if you have someone who comes in and says, I think that I've been discriminated against on the basis of my age, and in the intake process, well, how old are you? I'm 30 years old. Our statute does not cover you till you're 40 for age discrimination. It's that kind of information that it's a give and take to let them know the law. It also is a time when our office can explain what the proceedings are, and the employee can determine whether or not they want to go that route. Oftentimes, things are resolved during that period very easily. Confidentiality is not meant to be a gag order. Mm-hmm. It's confidential primarily for the Office of Compliance. We don't call up the employing office and say, your employee has come in to see us about X, Y, and Z. What it is the employee still has the ability to go out and talk to their friends and neighbors and say, my supervisor has done A, B, and C. We don't contact the employing office. It is maintained confidentially so that the employee has a chance to learn the system, learn what the laws are. One thing about the 30-day period, the law specifically says that 30 days can be cut short on the request of the employee. So if the employee comes in and gets the information that they need and they say, fine, I know what I'm going to do, counseling ends, and it may last one day. So it doesn't have to be a 30-day period.
Talk to me for just a minute, if you would, about the mediation phase, and what, just in general terms, what percentage of cases are resolved during that part of mediation?
I don't have the specific statistics on it, but what I've been informed about from my staff is that about 40 to 50% of the cases are resolved during the counseling or mediation period. So that's a significant amount that are resolved. The mediation process is very similar to mediation that Congressman Byrne would have seen with the EEOC. It is not required that the employee attend. This is particularly important for employees in our district offices. It is not required that they sit in the same room with the person that they are accusing of sexual harassment, for instance, in this instance. They can be in separate rooms. I've done countless mediations in my private practice where the two may never even look at each other. They may be in separate conference rooms, and the mediator will go back and forth. So I think it is a valued procedure. I don't know the legislative history as to why Congress put it in there, but we have seen that it works. It does not have to go 30 days. Okay. If they meet together and the mediator, and they say this is not going to be resolved, they can cut it short and the next process starts.
Ms. Lett, if I may ask you on the training that you referred to, you have obviously an online training, and then you will also do in-person training. How much of your in-person training is done here in the DC offices versus in district offices?
We do training typically when the office asks for training. They ask for training for their entire staff. So we will do the training here in DC and in the district office as well.
Gotcha. Would you, I know you're obviously, the officers will typically contact you before they take employment actions, I assume. For example, do they contact you before taking employment actions or contact you generally regarding sexual harassment awareness?
Congressman, I wish all of our clients contacted us before they took employment action. It doesn't always happen that way, but it typically does happen that way. And we work with them to get to the underlying issue, to find out if there's any merit to the allegation, to do an investigation, and then take appropriate corrective action.
And you would usually come in during the mediation phase from OOC. Are you ever contacted before OOC, or is it typically just following what you hear from them?
I mentioned earlier that sometimes we will know that an employee is going to go to the Office of Compliance. What the courts have said is that if an employer takes appropriate corrective action designed to stop the behavior, they are going to be insulated from liability in hostile work environment cases. But sometimes employees are not satisfied with that, so they will go to the Office of Compliance, and we expect it. As Barbara just mentioned, the counseling phase is confidential, but the employee can waive that and reach out to the employee. Typically, we will find out about mediation when there's been a notice of mediation issued.
Thank you both very much. Chair will now recognize Ranking Member Mr. Brady for the purpose of questions for 5 minutes.
Thank you, Mr. Chairman. I have a question for both of you. It is important to have staff and managers participate in the anti-harassment training for the betterment of the workplace. Can you speak on how anti-harassment and discrimination training directly relates to less complaints and a better working place? Either one.
I can take that one. I think it's very important that employees understand what sexual harassment is, that they have a right to come forward and report it, and that they will not be retaliated against if they do so. And that's what training accomplishes. It gives them knowledge. I think that will invariably lead to less complaints because an employer can address an issue before it becomes a formal process where they go to the Office of Compliance. I just ran into a chief of staff that I've known since I started in the Hill in 1996, and she told me in her experience she's only ever had one situation with sexual harassment, and I know that there are obviously many cases that go unreported. But she said that it was a staffer in the office. He said something that was inappropriate. She called him into her office. She read him the riot act, and she told him if it happened again, he would lose his job. So oftentimes, if employees are aware of these issues, it can be addressed at the earliest possible stage for the employee. And that's what we all want. We want employees to have safe and productive work environments. And I think it's important for employers to say to their employees, please come tell us. When we do the training for the managers, we tell them how important it is to talk to your employees, to walk around, to respond to rumors or anything that you hear where someone might be feeling uncomfortable, and then have a conversation with them. Oftentimes, these things can be addressed at the earliest possible stage.
I agree with everything that Ms. Lett said. The one thing I do want to add to it is that training is yet another opportunity to tell the employees, here is where you go if you have a problem. There's this entity called the Office of Compliance. One of the things that we're hearing so much in the media is that people on the Hill don't know who the Office of Compliance is. If there's a trainer in front of you that says there is this body, the Office of Compliance, and this is where you go to make a complaint, there's no reason why any employee on the Hill shouldn't know who we are and where we're located and how to make a complaint. I'd like to correct one thing that I said about the mediation process, that is a 30-day period that cannot be waived, and I misspoke on that.
Most of the complaints about harassment that are filed with the Office of Compliance are coming from non-member and non-committee officers, such as the AOC, CAO. How can we make staffers and members and committee officers feel comfortable speaking up on their issues with harassment or discrimination?
Well, I think that training, in training that I've done in my private practice, and I think that Ms. Lett indicated the same thing, is it can be a dialogue. It can be talking about what is appropriate and what isn't appropriate. One thing I think that needs to be understood is there is illegal sexual harassment and there are bad practices. And some things don't, a complainant might not win in court with what their complaint is, but they can still ruin the morale of an office and be inappropriate. And I think that the training, in-person training in particular, can go into both areas of what's illegal and what is inappropriate for this particular office. I think one thing that Congressman Burns said in his statement about having a universal policy is very interesting, so that everybody's working on the same page and everybody knows, even in the office, as Ms. Lett was saying, where do you go to complain within your office? But also a necessary component has to be who OOC is and what our purpose is in the whole process.
And I agree with that, if I may respond. It is very important to have written policies. There is a model sexual harassment policy that is part of the model handbook that this committee makes available to House employing officers. We work with the committee staff to develop that. And that policy basically sets out zero tolerance for this type of behavior and tells employees of the consequences if they do participate. But training is vitally important. When we do training, in-person training, it's amazing to see how men and women might have very different reactions to the same conduct that they view in the videos. And when they have that dialogue, it helps to inform both groups of where they're coming from and why it's problematic and unwelcome behavior.
Thank both of you. I yield back, Mr. Chairman. Thank you.
Gentleman yields back. I would ask witnesses maybe pull your microphones a little closer to you, so we're having some background noise. And the chair will now recognize the Vice Chairman of the committee, Mr. Davis, for the purpose of questions for 5 minutes.
Thank you, Mr. Chairman. Thank you, Ranking Member, for hosting this hearing. And I'd like to thank my colleague, Bradley, somebody who practiced employment law in Alabama. I think many of the comments in his opening testimony were very well stated, and the powerful testimony from my colleague Jackie, thank you. And then also the opening statements of Barbara and Susan, thank you for your testimony and your comments. I think it's long overdue. And I appreciate both of you and your opening statements, because no one should have to worry about sexual harassment in the workplace. And as a former staffer, one of the reasons I wanted to serve on this committee is to continue to professionalize the House and establish a workplace that is grounded in respect. I look forward to discussing with each of you the potential areas in current policy that need improvement and any areas you suggest we need to make better. Because in Congress, we've got to lead by example. My first question for both of you is, it's important we get this right. And I have a female-led staff, and I asked them their opinion. And they were concerned, some offices, that an unintended consequence may be that some offices may just take a shortcut and not hire women as a way to avoid these issues. And obviously, that's not the right approach. How do we ensure that we use this moment to work toward true prevention of sexual harassment while also continuing to make Capitol Hill a place of opportunity for female professionals?
I think that one of the things that is just tremendous is to see women as members. And I think that I'm not as concerned about that with the strong, fantastic women that we have as members. And I think there's great wealth of experience and talent out there with females, and I would certainly hope that that would not be a consequence of harassment.
Agreed.
Training.
And my office certainly has had discussions with, we've heard that, and we've had those discussions with our clients to remind them that that's unlawful. Obviously, individuals should be hired based on their merit without regard to gender. But again, I think it's very important to have training. I keep coming back to that, and we do training on hiring techniques and things of that nature as well. But just awareness is very important with respect to that issue.
Thank you both. Ms. Childs-Wallace, what challenges does the OOC face in carrying out its educational duties? And for example, I'm a former district staffer, so how does the OOC reach out to the district offices, and how can we as a committee be helpful?
Well, there are several things, I think. First of all, one of the recommendations that we have made every other year is with regard to these posters. We are required by statute to develop these posters. These are the kind of posters that are posted in workplaces in the executive branch and in the private sector. And we do, and we hand them out, and there is no law that requires anybody in Congress to post these notices. They are a notice of rights. They also talk about OOC. These can go in the district offices too. We do training with another outside organization through, I'm blanking on the name of the organization that does training in the district offices, and also the online modules of training that we have been developing and are continuing to develop more and more can be taken by employees in the district offices.
Okay. Thank you. Thank you. Ms. Lett, if an employee in office conducts an internal investigation, what role does OHEC play during the investigative process? And are there internal investigations that are resolved, I think you mentioned some, without using the OOC process?
When an office contacts us and there's an issue of sexual harassment, we work with the office to conduct the investigation. We give them materials that are very exhaustive. Not every situation requires that they learn this 25-page document of instructions on how to conduct an investigation, but we work with them at every step of the way. Some offices, their staff is very savvy, very comfortable doing investigations. And when I say investigations, in some instances, it may mean talking to 2 employees and figuring out what happened. But some offices aren't quite as comfortable with investigations, so what we will do is we will help them to get the help of an independent outside investigator. And that investigator will get to the bottom of what's going on, report it to the office, and then we will work with that office to figure out what the appropriate corrective action is.
Thank you both. I yield back.
Gentleman yields back. The chair will now recognize Congresswoman Speier for 5 minutes for questions.
Thank you, Mr. Chairman. Let me ask you, Ms. Lett, that whether or not you end up representing the harasser in mediation or not?
Our client is the employing office, so we never represent an individual. At the end of the day, someone obviously is accused of harassment, but they're not our client. The client is the employing office of the member or the committee or the House officer.
So I think we're mincing words here. Let's say a member is being accused of sexual harassment. You are representing the member, correct?
We are representing the employing office, which sometimes can also be the member, yes.
Do you think that's appropriate?
I think it's appropriate given our role. Our role is an in-house law firm. We're no different than a private sector company. They have their own lawyers to represent them in these matters. And under the Congressional Accountability Act, the House employees were supposed to experience the same thing as private sector employers. So the situation is analogous.
So when you're representing, let's, for discussion purposes, say the member, it's your job to try and resolve this so that the member is kept whole and none of it becomes public. Do you ever find yourself in a position of saying to the victim, you know, if you pursue this, your career on Capitol Hill is over?
My office absolutely would never say that to a victim. Our role is to assist the office in getting to the bottom of what's going on and to take appropriate action. In the case, we've had a couple of cases where the member was the individual who was accused of the harassment, and there are corrective steps that can be taken to make sure the member acts appropriately in those circumstances. Our office does not have the ability to discipline a member, but certainly the Ethics Committee does. And leadership can interject in those situations as well.
But if you settle a case between a member and a staff member, it never goes to the Ethics Committee, correct?
That's not necessarily true.
Well, how would it go to the Ethics Committee?
A staffer could bring a claim, can contact the Ethics Committee. Anyone can contact the Ethics Committee and allege that a member has acted inappropriately.
And kiss their job in Capitol Hill goodbye.
That's not the way it's supposed to work, Congresswoman. Certainly, we assure, we have the employing officer assure any employee who raises these claims that they will not be retaliated against, because if they are retaliated against, the office can be sued for retaliation.
It is true, though, that the staff member must be in continuous employment in order to access the services of the OC. Is that correct?
I don't think that that's correct. I assume that the
well, if they're no longer employed by the House of Representatives, then I've been told that this office is not available to them.
I don't have that information.
All right. What percentage of your mediations is between member and staff versus staff and staff?
I'm sorry, Congresswoman, I can't hear because of the background noise.
What percentage of your mediations is between member and staff versus staff and staff?
Overwhelmingly, the mediations concern staff and staff. It's very rarely when it involves a member, but those occasions have occurred.
Okay. Now, we've been told that if you are accusing someone of sexual harassment, that you are required to be in the same room. It's only in cases of sexual assault where you can be in separate rooms.
That is not true. You're not required to be in the same room. I can tell you for my office, typically when we go to mediation, oftentimes we don't take the alleged harasser. We find the mediations to be more productive if we take someone else from the office who's in management, someone who's familiar with the underlying issues. I don't find it to be particularly productive to have a alleged harasser and a victim sit across the table from each other, so that's not how we approach it.
Have you ever counseled an accuser that if they don't want to be in the same room, that the legitimacy of their complaints would be called into question?
Can you give me that one again?
Have you ever said to someone who was an accuser, a victim, who did not want to be in the same room, that in so doing, it would cause you to wonder about the legitimacy of their complaint?
I don't recall ever doing that. It's really up to the employees' counsel to make that decision about whether or not they want them to be in the room, so it's not my call.
Okay, I yield back. Thank you.
Congresswoman Speier yields back. Chair will now recognize Congresswoman Comstock for 5 minutes for the purposes of questions.
Thank you, Mr. Chairman. I also appreciate testimony of my colleagues, and particularly very detailed additional things that we can do that Congressman Byrne laid out. And one of them that I wanted to focus on was really giving the members and, say, senior staff some strict guidelines. And so taking my example of the member in the towel, we really don't have current guidelines right now that say to a member, say, a sexual relationship with a 19-year-old intern is off limits. Is that at all clear right now? Because I haven't seen that in some of the materials, just flat out. You can, your chief of staff can't, your senior people can't, you can't, we have these young interns, we have young staff. It doesn't say you cannot have this in our office.
I'm not aware of anything that says that specifically. As someone alluded to earlier, obviously the Code of Conduct, which says that a member and staff should conduct themselves in a manner at all times that reflects credibly upon the House, would be relevant in that context, but I don't know of a specific writing that says what you've just mentioned.
Okay, and I sort of, if for any Seinfeld fans, the George Costanza rule, where he got fired because he didn't know it was inappropriate to have sex on the desk in the office with the staff. I think that's something we do need to make clear from the member on down, because wouldn't you agree it creates a hostile work environment if there is that kind of relationship in an office?
No question about it.
Okay, so that would be something when we're looking at just the hostile work environment, like say in this example, I think I would have done what this woman did, go find another job. Not everyone can do that. But if she had gone along with this, then that is creating, that can go into creating a hostile work environment, right, for the other women in the office?
Of course, and I would hope, again, that an employee would feel comfortable complaining to whoever would be appropriate in those circumstances. The way the model handbook policy is written, the employee is told, asked to report it to either their immediate supervisor or anyone in management with whom they feel comfortable making that complaint.
Okay. And I appreciate you highlighting how the videos and the interactive, having people together, because I know when I was at my law firm, we had that type of thing in our training, and I do think that's an important aspect of what we need here. So as we're looking at this, any of the additional, I've been told, for example, the Navy does a good job. Other federal agencies have materials. Perhaps it would be good for us to get more examples, if you can provide us, of some of the things that the other agencies in the private sector are doing. I think that would be helpful as we look at this. And then I had also wanted to ask about one of the suggestions that Dorina Bertucci, who is the first woman who I spoke to, that she suggested was an ombudsman. And I think it gets to some of the questions that Mrs. Speier had, where there's sort of, your job is what Congress has told you to be at this point, and we're looking at how we might change that. But if we were to have an ombudsman who is that victim's support person, then that could be somebody maybe who would say, you know what, this is a criminal case, and you don't need mediation here. You need to go and deal with this legally. Or, here's the process of what you do if you were to go to mediation or do these things. But have somebody who's really that victim's advocate. Is that something that you've seen in other workplaces, or maybe given the unique nature of our workplace might be helpful?
I have seen it in other workplaces. I believe at one time the Capitol Police had an ombudsman that their employees would go to raise concerns. And it can be a successful model depending on how it's structured.
And how are you telling staff when there are criminal cases here? And I know from, as I mentioned, as an intern staffer, when you heard criminal activity that went on. People who wouldn't go forward because they were afraid to. Is that something that's, because I think it's saying we tell people it's criminal, but really letting them know all of the things that are actually going on so they feel like they're not alone and they can go forward, that this has happened before, and, to report something criminally.
I can say for our office, that's not our role. Our role is to provide legal advice and guidance to employing offices under the Congressional Accountability Act.
But is there anybody identifying when something clearly is a crime?
I'm not aware of it.
Yeah, I think that may be something we really, Mr. Chairman, that we really need to look at, because it may just be if you had a situation where somebody thought, oh, I was out with the boss, this happened, it was my fault, and we need to tell them, no, that wasn't your fault.
Will the gentlelady yield? Would you yield?
Yes.
One of the components of the legislation that will be introduced would have the victim be represented by a special victims counsel, much like in the military now we have created that mechanism for victims of sexual assault.
Yeah, and then, but also, because at that point, but somebody sort of having that intermediary determination, like, here's all the different places you can go. Here's the crime, here you could have somebody, but also have somebody to talk it out with before we, decide what to do, the individual, so they feel like they are covered more in some way. So maybe we can discuss that.
Ostensibly, that's what the counseling component, that first 30 days of what is called counseling, is actually legal counseling. It can be 1 day, it can be 1 hour, but it ostensibly takes place there. But again, I'm not convinced that the system we have in place protects the victim at all.
Yeah, agreed.
Chair will now recognize the gentleman from North Carolina, Mr. Walker, for 5 minutes.
Thank you, Mr. Chairman. Thank you for your prompt leadership in this very certainly important issue. I would like to thank my colleagues for the earlier testimony and all the people that have spoken on this. It's a very important issue. And I'm grateful to stand with such staunch advocates in our work to make the House of Representatives a respectful and safe environment for our fellow colleagues. As a minister, a pastor for nearly 2 decades, sadly I've heard too many similar stories over the years. This type of behavior should never be tolerated. Here or in any other work environment. I believe that we should lead by example and set the tone for the nation. And in leading by example, I was encouraged by our chairman to strongly encourage members of this committee. So we have gone, certainly in our entire staff. I'm also chairman of the Republican Study Committee, so all 28 staffers as well as myself have gone through some of the very clear and productive training, and I hope that will lead to even more. Ms. Childs-Wallace, early this month, the Board of Directors wrote to the Speaker of the House and the President Pro Tem reiterating its call for mandatory anti-discrimination and anti-harassment training. Is mandatory training the most effective deterrent to the problem of sexual harassment?
It is one component of it. I think that leadership from within each office is also important, and letting the employees know where they can go to complain is vitally important. But mandatory training is one very important component of trying to stop this.
You say one very important part. In your research, are you able to boil down or identify what you would say is the most effective component of this?
Probably mandatory training.
Okay. All right. Is there any other deterrent that you would believe that would be equal or part of this process?
Well, like I said, posting these notices and letting people know who we are and where they can go is important. And then leadership from the top as to what is appropriate and what is not appropriate.
I believe, if I'm correct, also cited in this letter to the Board of Directors, this recommendation has been made since 1996. Is that correct?
We have made it many, many times, and I can't give you the exact number, but it is in our biennial reports that we recommend this.
Well, can you tell me, was it first identified in 1996, or did earlier prompts of concerns kind of get this thing moving?
I was not on the board until 1999, so prior to that, I can't tell you necessarily.
So we don't have any records or evidence?
We do have records, and we can, if if the committee would like, we can go back and look at all of our 102B reports and give you the exact dates that we made this recommendation.
Right. Fair enough. Ms. Lett, in your opinion, what improvements can be made to the adjudication process administered by the Congressional Accountability Act?
I have, I guess, a different take than what seems to be happening or the position. I think it's a very effective process. We have lots and lots of cases that are resolved through that process. Employment cases, in general, the overwhelming majority are resolved before full-blown litigation. And I think the statistic is 85% of employment cases are resolved before full-blown litigation. I believe in this process. I mentioned this before, that once someone goes to the Office of Compliance and we engage in mediation, we may be hearing about the problem for the first time. But we do an investigation and we get to the bottom of what's going on and we make recommendations to the office for corrective action. So as I said, I believe in the process as mandated by the statute, and I think it works very effectively to address the issue of sexual harassment, just as it does for other forms of harassment and discrimination under Title VII.
Okay. Thank you for your responses. With that, I yield back.
Gentleman yields back. The chair will now recognize the gentleman from Nebraska, Mr. Smith, for 5 minutes.
Thank you, Mr. Chairman, and certainly thank you to our witnesses, our members as well, for bringing insight and expertise to these very serious issues. We've talked a lot about the prevention or preventative measures that can or should be taken. I was wondering if you could speak more to what types of resources, whether it's funding or other resources that either one of you think would help empower individuals throughout these processes.
I appreciate your asking that question. Let me put it in the context of the Office of Compliance. If we are tasked with mandatory training throughout Capitol Hill, we right now have 2 employees who work on training along with other issues. It's going to be vitally important that we obtain funding to add what we figure is probably 3 more FTEs to help us do the training. So that is one thing, and also help with our IT process in the office. Like I said, we are a very, very small office. Other things, I think that that training that both of us do, those are the resources that are just essential.
Ms. Lett?
For my office, we do a lot of training. We've gotten a lot of training requests in the last several weeks. We do the training here and again in the district offices. We've ramped up our training efforts, so we have multiple trainings occurring in any given day. We've ordered additional equipment, and that seems to be working very well. But I think if ultimately the decision is that there's going to be a requirement of mandatory training, and I really urge that for management, we may also need to have some additional staff hired to get that all accomplished.
Okay, thank you. Thank you, Mr. Chairman. I yield back.
Gentleman yields back. The chair will now recognize Congresswoman Brooks for 5 minutes.
Thank you, Mr. Chairman. Ms. Lett, you talked about that the large majority involve staff-on-staff issues. Can you share with us at what point in the process the member is informed when a staffer comes to OHEC and initiates the process with OHEC? When is the member brought into the process?
The member is really brought into the process from the very beginning, because if an employee goes to supervisor or management, that's going to go up the chain of command, and the member will be informed. So we will get calls from a chief of staff who has told us that they've already spoken with the member, or we'll get calls directly from the member.
And if it involves a chief of staff?
If it involves the chief of staff, we would typically get the call directly from the member.
And But if a staffer had come in to OHEC directly, would you call the member if it involved the chief of staff?
Actually, we don't talk directly to staffers. That's not our role because we are lawyers for the employing office. So if a staffer calls, we essentially will encourage them to go back to their management and speak to them because management can address a lot of these issues. And if they're not satisfied with that, then they can go to the Office of Compliance. But the only time we talk directly to employees is when we do training, employee training.
And if you do get that inquiry from a staff member and you do not hear from anyone after that, does anything happen?
We do follow-up with offices to let them know that we've heard from someone and that there may be an issue in their office that they need to take a look at.
And for both of you, you both mentioned, large percentages of resolutions prior to litigation or in lieu of litigation. Can you give us examples of resolutions?
Well, I can speak to that. If there is an allegation that a coworker is making inappropriate statements in the workplace or send an inappropriate text or email or something of that nature, we will have the employing office, a management employee, talk with both the person who is complaining about the behavior and the person who is the harasser to get to the bottom of what's going on and then figure out what the appropriate steps may be to address the behavior. And that could include counseling, that can include training. We do one-on-one training quite a bit, actually. That can include training for the staff, and it may also include some type of disciplinary action, a letter of reprimand, suspension without pay, and as for the more egregious cases, of course, termination.
Thank you. Anything, Ms. Wallace, that you'd like to add with respect to resolution?
Sometimes in counseling, if we look at it not necessarily in the harassment context, but if someone came in and said, I'm not afforded the same kind of training as the males in my office, and it could be as easy as once the employer is informed about it to say, we didn't know you wanted it. Yes, let's get you on the next training on this. And that's a more simple resolution that doesn't require payment of money in a settlement or something like that. In a sex harassment context, it could be changing who your supervisor is, moving you to a different position or moving the alleged harasser to a different position so that there's no longer within the line of supervision.
May I address that issue?
Yes.
One additional point. An important part of the resolution is to get back to the person who complained to let them know that the office has taken the matter very seriously, has looked into the matter, and has taken appropriate action to make sure it stops, and to remind that individual that they cannot be retaliated against, and if there's even the remote hint of retaliation, that they should come back to management to take care of it.
And since I am here representing the Ethics Committee in many ways, can you both mention any improvements you might make relative to coordination with House Ethics Committee, and do you inform a complainant of that option of pursuing their allegation at the Ethics Committee?
I'm not as, I have to admit, I'm not as familiar with the ethics procedures. I do know that if someone goes to the Ethics Committee and wants to make a complaint about sex harassment, they are most likely directed to our office, which I do believe is appropriate. But I would welcome any kind of coordination between the Ethics Committee and the Office of Compliance. I think that would be wonderful on this issue. One thing I'd also like to say in the context of all of this is we don't want to limit this training or the ethics coordination to just sex harassment. There are other kinds of, it is the issue of the day and the most important one, but there is harassment that occurs in other contexts, whether it's racial harassment, disability harassment, that the training should also address and try and stop. But yes, nothing excites us more than the fact that Congress right now is looking at the issue from the standpoint of sex harassment.
Ms. Lett, any recommendation with respect to ethics?
One of the ideas I think that's been mentioned is the idea that there be a record of the employees having taken sexual harassment training, much like there's a record created when we take ethics training. And so I think that would be a great idea to coordinate with your committee to make sure that those records are maintained to show that employees have indeed received the training.
I agree with that 100%. I think that's good.
Thank you, Mr. Chairman, again for including me. I yield back.
Thank you, and I'd also like to certainly thank Congresswoman Speier and Congresswoman Brooks for joining us today for this hearing. It's been very helpful to have your participation. Without objection, all members will have 5 legislative days to submit to the chair additional written questions for the witnesses, which we will forward and ask the witnesses to respond as promptly as possible so that it can be a part of the record. I want to thank all of our witnesses for being here today. I know that Mr. Brady joins me in saying it's apparent that mandatory training is a necessary first step to improving the House's process to address sexual harassment in the workplace. The committee will continue to review the testimony given today, work with members, and make additional recommendations to strengthen the process to ensure that the congressional workplace, which includes not only the members of Congress and their offices, but includes all of the officers of the House, the architect, the Capitol Police, all of these things have to be included. Congressional Budget Office and, of course, Office of Compliance. All these things are included in 1995 when Congress passed the Congressional Accountability Act. This type of behavior cannot be tolerated. And so I believe that raising the awareness today, we should set the standard of proper conduct in the workplace, and I hope this is the first step to getting there. Without objection, I'll recognize Mr. Brady.
Just for 1 second, I just want to say something to my colleague from California that I didn't agree with you. You said this is an uncomfortable thing for us to do. I have a wife, a daughter, 2 granddaughters, and a great-granddaughter. It's not uncomfortable. It's our moral responsibility and obligation to protect somebody else's wife, daughter, and granddaughters. So I thank you, and thank you for your courage. Thank you, Mr. Chairman.
Thank you, Mr. Brady, and I associate myself with your remarks that you just made. Without objection, this hearing is adjourned.
All right, let's begin.